Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to Our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is John Roberti, and today's topic is, what did we learn? Ida Tarbell and the role of theory versus fact in shaping antitrust law. These are definitely interesting times to be an antitrust lawyer. We're facing a period of real rethinking of the antitrust laws. And at least some of the impetus for that, or a signature event, was the publication of an article a few years ago about Amazon and rethinking the antitrust law standards. Well, more than 100 years ago, there was an article that was very influential about the antitrust laws back then. It led to, some argue, it led to the creation of the FTC Act and the Clayton Act. And it was a series of articles by a woman named Ida Tarbell, who examined the role of Standard Oil as a monopolist and how that was harmful. Today, we're going to talk with an expert who has thought a lot about the Standard Oil case, and we're going to talk about how what we learned in Standard Oil may apply and what may be different in today's world. My co-host today is Tammy Sue. Hi, Tammy.
Hey, John. How are you?
Good. Tammy, what are we doing today?
Well, as you say, we are learning more about Ida Tarbell. I think that's where we want to start our conversation today. She was an American investigative journalist in the late 1800s and early 1900s, most well known for taking down Standard Oil through her book or her series on the history of Standard Oil.
Great. And who's our guest today?
Our guest today is Professor Christopher Leslie. He teaches antitrust law, among other classes, as the Chancellor's Professor of Law at the University of California at Irvine. He wrote a fascinating article on how an economist who barely relied on any empirical evidence was able to undermine Ida Tarbell's factual findings and, as a result, change the course of antitrust jurisprudence. His article is called Revisiting the Revisionist History of Standard Oil.
All right, well, let's bring you in. Professor Leslie, welcome to the program.
Thanks. Great to see you guys again, Tammy and John.
Great. So, Professor Leslie, why don't we start off talking a little more about Ida Tarbell? Who was she?
Sure. So, Ida Tarbell was raised in the oil fields of Titusville, Pennsylvania. Her father, originally a teacher, entered the oil business and was a moderately successful oil tank person. He was a leader in the community, was well known. When she was a teenager, he rallied with 3,000 other people at the Titusville Opera House against Standard Oil and the conspiracies that it entered into with railroads that were hurting local independent oilmen. So Ida, as a child, personally saw the oil business, saw what Rockefeller and Standard Oil were doing to independent oil businesses and to local communities. So she comes to this issue of Standard Oil and the effect of monopolies with some personal firsthand knowledge.
So what were some of her findings and accusations against Standard Oil? Just like a few, like one or two examples of practices that we're talking about here.
Sure. Would it be okay if I talked just a little bit about McClure's and how she gets to McClure's? Because I actually think that it becomes important later on.
Sure, let's talk about McClure's.
After Ida graduates from college, she starts to do some writing for a local publication called the Chautauquan, and decides that she wants to be a writer and wants to write a biography of Madame Roland, one of the leading figures of the French Revolution. So she goes to Paris to study Madame Roland, to learn research techniques, and continues to send back articles as a freelance writer. Samuel McClure's, a publisher, is starting his new eponymous magazine and knows her writing and and goes to meet her in Paris and is very impressed with the fact that she's learned all these research techniques as she's studied what Madame Roland's life was like. And McClure is starting his magazine with a new and different model. Instead of using anonymous sources, he decides he's going to have staff writers, which magazines didn't do. What that means is the writers have bylines and they become known as writers. And that's going to become important as Ida Tarbell gets to develop a reputation as a writer. So she writes serialized biographies of Abraham Lincoln and Napoleon Bonaparte and becomes a well-known writer at McClure's. When McClure's decides that they need to write something about the trusts, they think about writing about the beef trust or the sugar trust. But in conversations among all the staff writers, Ida tells them about Standard Oil, and given her firsthand knowledge of Standard Oil and her passion on the subject, they assign her the task of writing about Standard Oil. And so that's how she comes to this as a staff writer at McClure's who has the resources of the magazine to fund her research. So they give her an assistant, and they start out to research what Standard Oil is doing, and they want to do it before they talk to anybody at Standard Oil because they want to get their ducks in a row. But Standard Oil finds out that McClure's and Ida Tarbell are researching them. And so Henry Rogers, who's one of the top executives at Standard Oil, is friends with Samuel Clemens, Mark Twain, and he knows that Mark Twain is friends with McClure's, with Samuel McClure. And so Mark Twain arranges the introduction between Henry Rogers, I think the number 3 person at Standard Oil, and Ida Tarbell. And he invites her to come and research in Standard Oil's archives. And she spends almost 2 years there at Standard Oil's archives researching the actual data from Standard Oil, having regular communications with Henry Rogers. And I think that's important to get a sense of that she's got access to real data. And so her findings are informed by that. She also gives her drafts to Henry Rogers for his feedback, for his comments, to make sure that she is getting things right, or at least to give Standard Oil an opportunity to push back.
That's really fascinating, because I would think that Rogers would have said, no, you're actually not getting this right. We're not a monopolist. We're not the terrible person you think we are. But yet, here we are, right?
It seems that Rogers wants to get ahead of this. He doesn't want Ida to only get her information from Standard Oil's perceived enemies. And he also wants to have some input because he thinks Standard Oil isn't doing anything wrong. Another part of this is Rogers doesn't think that he's doing anything wrong and wants to make sure that the story is told in a way that he's not found to be complicit in anything. But you're absolutely right, John, that it's interesting that Rogers has this input, but he doesn't have veto power over anything. Ida was very clear that she would not be compromised. And in fact, even though she met regularly with Rogers at the Standard Oil headquarters and at Rogers' house, she made sure that there was no undue influence, that she wouldn't even accept a glass of milk unless she could pay for it, because she didn't want there to be anything that would make her look like she was compromised. But Rogers started to get frustrated when Ida Tarbell would reject his comments. And he particularly got angry when he learned that she was investigating allegations that Standard Oil had maintained an industrial espionage operation against Standard Oil's rivals, something that Rogers vehemently denied. And that was sort of the breaking point between the 2-year now ongoing working relationship between Ida Tarbell and Henry Rogers, when she was pursuing this line of inquiry about the espionage network. As it turned out, Tarbell was right, and she later proved with Standard Oil's own documents that Standard Oil had a huge espionage network, that it was paying spies to spy on Standard Oil's smaller competitive threats. And The evidence for this comes from a teenage clerk working in the Standard Oil office whose job was to burn documents in order to destroy them. And one day, as he's burning these documents, he looks down and he sees the name of his Sunday school teacher. And so he pulls that document out, and his Sunday school teacher is also an independent oil refiner. And he sees that this is espionage against his Sunday school teacher that Standard Oil is performing. And so he gives it to his Sunday school teacher, the independent refiner, who now has the proof that Standard Oil is spying on him. But what do you do with this information if you're a small business person and you find out that this big company is spying on you? My students won't believe this, but there was no internet. There's no obvious place to turn. So where do you turn?
Ida Tarbell.
Perfect, John. Full points. Because she's made a name for herself. She's got a byline, and they've already started publishing this serialized expose of Standard Oil. And so he knows where to go to with this information, providing it to her. And that's the smoking gun that is really one of the huge takeaways, that Standard Oil had so vehemently denied that they were doing this. And Ida had the proof of it. And she got the proof in part because she had made such a name for herself as a respected, credible investigative journalist.
What did Ida Tarbell's findings have to do with antitrust law? Did it end up in court? How has it shaped antitrust law?
Sure. So it takes a little bit of a circuitous route to get there. So what her findings reveal are a series of bad conduct, many of which look like antitrust violations now in retrospect. So the railroad rebates, the fact that Standard Oil was essentially orchestrating a cartel among the railroads, and the price that it received, or the wage that Standard Oil received for helping orchestrate the railroad cartel, is that Standard Oil got rebates for shipping its oil, while all of its competitors had to pay a much higher price. Which gave Standard Oil ability to raise its rivals' costs, drive them from the market. She also showed how Standard Oil had used forced acquisitions, had used threats and its espionage network in order to purchase its rivals, often for less money than they were probably worth. But when you're bargaining in the threat of Standard Oil putting you out of business, you don't have a lot of leverage. And part of that leverage was the threat and actuality of predatory pricing, that Standard Oil would engage in predatory pricing in those markets where it faced competitors. And so that's just some of the anti-competitive conduct that Ida exposed. What that did is everybody was already angry with Standard Oil. But she actually provided facts in a one-stop, accessible manner that showed this bad conduct. That informed state attorneys generals to start going after Standard Oil. And there were important cases in Missouri and Kansas. And it also then informed the federal government's case against Standard Oil, which led to then the Supreme Court opinion in Standard Oil that famously led to the dissolution of Standard Oil. So it's not a straight line, but it's pretty clear that her investigative research that led to her 800-page book, The History of Standard Oil, which became an incredible bestseller, had a lot to do with informing both factually and getting people behind the notion of taking legal action against them.
What about the Clayton Act and the FTC Act? How does that play in, if at all?
Well, certainly after the Standard Oil case, there's more attention paid to antitrust, and there's attention that's being paid to perceived holes in antitrust law. And so a lot of what the Clayton Act is filling those perceived holes. So that's things like Section 3 of the Clayton Act, making tying arrangements illegal because the Supreme Court in A.B. Dick said that they weren't illegal. The Clayton Act also, of course, made certain mergers and acquisitions illegal to plug the hole that the Sherman Act was not being used to stop mergers. Standard Oil is relevant to that because Standard Oil was this huge wave of mergers and acquisitions that led to the monopolization of the oil industry. And Ida Tarbell showed how Standard Oil was engaging in nefarious conduct and threats in order to force these acquisitions, and antitrust didn't have a way of stopping those acquisitions. The other thing that Ida Tarbell's research in Standard Oil probably informed the Clayton Act is part of the Clayton Act, of course, was about price discrimination in the form of sort of predatory pricing, but this notion that firms that operate in several markets, if they have a monopoly in some markets, if they take those monopoly profits and use that to cross-subsidize lower prices and including below cost prices in other markets, that's something that antitrust law should care about. Section 2 of the Clayton Act, which later became the Roberti-Patman Act, that was informed by Standard Oil doing precisely that, of pricing like a monopolist where it could, using its monopoly profits to price like a predator in order to destroy its rivals in those local markets until it could monopolize those markets and then price like a monopolist in those markets.
So I want to spend a minute talking about predatory pricing. You mentioned that, hey, predatory pricing is one of those tactics that Standard Oil was using that to crush its competitors. But when I was in law school about a decade ago, like predatory pricing wasn't an anti-competitive, it wasn't a tactic that was really recognized as anti-competitive. And then a few years back, I read Lina Khan's article on Amazon, which was kind of trying to reintroduce, hey, look, predatory pricing is real, and companies engage in this, and it creates anti-competitive harm. So how can you help us thread the needle of how it seems like Ida Tarbell had identified and uncovered facts to support that predatory pricing tactics engaged in by Standard Oil was in fact unfairly destroying Standard Oil's competitors, and at one point was that recognized as an anti-competitive behavior?
Absolutely. So one of the holdings of the Supreme Court's original Standard Oil opinion was that Standard Oil engaged in predatory pricing and below-cost pricing, and that was one of the forms of anti-competitive conduct that meant Standard Oil is an illegal monopolist who should be broken up, which is what happened. The change really occurs in the mid-50s with the birth of the Chicago School of Law and Economics, that in the very first volume of the Journal of Law and Economics, economist John McGee published an article on Standard Oil and predatory pricing, saying that Standard Oil never engaged in predatory pricing. The famous quote from the article is, "I cannot find a single instance in which Standard Oil used predatory price cutting. I do not believe that Standard even tried to do it. If they tried, it did not work." And he pitched this as an empirical piece that proved Standard Oil never engaged in predatory pricing. And that article was incredibly influential. I mean, the Supreme Court cited it in Matsushita when the Supreme Court said that there is a consensus among commentators that predatory pricing schemes are rarely tried and even more rarely successful. McGee successfully changed the meaning of the Standard Oil case. That the litigation showed Standard Oil engaged in predatory pricing, and that is anti-competitive conduct. And McGee said, nope, I read the trial record and there's no predatory pricing. And Standard Oil then became this an example of predatory pricing doesn't happen. What's troubling about that is McGee's work is sloppy, to be generous, and just oversweeping in its conclusions. He just reviewed the trial record and said, I don't see it, but he didn't look that hard. That if you look through the trial record, there's lots of examples of Standard Oil engaging in local price cutting in markets in order to drive all the competitors out, and then once they're gone, to hike the price. And if you look at McGee's examples of him concluding there was no predatory pricing, a lot of them are examples of a former Standard Oil employee saying, yes, we engaged in this below cost pricing, and a current Standard Oil employee saying, no, we didn't. And McGee says, well, that proves they didn't. It's just baffling that you think that that is proof that predatory pricing didn't happen.
Professor, as part of this, Dr. McGee sort of ideologically believing that predatory pricing just doesn't really happen. And in a sense, his theory sort of sweeping away the facts from Standard Oil.
Absolutely. That McGee comes to this as an early Chicagoan with a theory that says predatory pricing doesn't exist. It's not rational. Nobody would ever do it. And so he comes in with this theory, and basically he says predatory pricing is irrational. Therefore, Standard Oil wouldn't do it because Standard Oil is rational. And therefore, I've proved empirically Standard Oil didn't do it. Look, that's not what empirical means. For him to claim that I've proven that Standard Oil never priced below cost is just bizarre, given in his article, he literally never mentions Standard Oil's prices or Standard Oil's costs, and yet concludes he's proven that they never priced below cost. Whereas Ida Tarbell actually has access to the documents, actually has examples. And although she's the first one to move on this, the Bureau of Corporations, which later essentially sort of evolved into the Federal Trade Commission, was absorbed by it, did its own study of the American petroleum industry. And it too found hundreds of examples of Standard Oil engaging in this using actual data. But McGee didn't need that data because McGee had a theory. And what he doesn't understand, and what I fear a lot of law and econ people sometimes fail to understand, is that when theory and facts collide, facts disprove theory. Theory can't disprove facts. And Ida Tarbell had facts. Ironically, the only time that McGee mentions Tarbell is in the epigraph of his article, where she says, Standard Oil is engaging in predatory pricing. And then he never mentions her data or work again in his quote unquote empirical takedown of the research. And yet McGee's work is the work that becomes influential and carries the day, and people mislabel it as empirical. It's worth noting that two other economists have revisited the trial record in Standard Oil, and they did it much more painstakingly. And they concluded that the trial record in Standard Oil contains considerable evidence of predatory pricing, and they go through and show examples of Standard Oil's own managers and salespeople showing instances of Standard charging below its variable cost in the Midwest, in Boston, in New York, and Colorado. I mean, this isn't isolated. This is a nationwide phenomenon.
So, Professor Leslie, we've talked about the theory and the facts. Can you explain for us a little bit about what was Dr. McGee's theory? Where was he coming from? Where did that come from?
Sure. So McGee had a theory that said predatory pricing should not occur because the targets of predation would simply re-enter the market as soon as the monopolist hiked the price up again. But empirically, that never happened. Standard Oil drove out hundreds of competitors with predatory pricing, and then raised the price to monopoly price, and the vanquished rivals didn't re-enter the market. So the one example he has is a different firm re-entered the market 11 years later, which sort of proves the point that entry doesn't happen for a long time, and the people that were vanquished don't actually re-enter. The other theory he had was that firms would never engage in predatory pricing because the predator, having the higher market share, would sustain losses that were significantly greater than the target. Because if you decrease your price below cost on all of your sales and you've got more sales, you're going to lose more money. And again, McGee failed to see what Ida Tarbell had exposed about Standard Oil, which was Standard Oil used its network of spies to figure out which rivals to target, and it created bogus companies like Eureka Oil and Eagle Oil. And these bogus companies would charge these incredibly low prices in order to lure customers away from rivals and drive those rivals out of business. As soon as those rivals went out of business, Eureka Oil and Eagle Oil disappeared, leaving the customers beholden to Standard Oil and its monopoly. If you actually sort of followed the facts of Standard Oil as revealed by Ida Tarbell, you would see that these theories that you've got for why predatory pricing shouldn't happen don't work in the real world. Facts disprove the theory.
So it sounds like to me, I mean, you've presented really strong evidence. It sounds to me that like the courts, the judges just got it wrong in history when they relied on John McGee's paper. In your opinion, what's the best remedy going forward? How do we fix this? Do we fix it?
You got to think education. In some ways, one of the things that's so attractive about theory is it's so easy. That theory says that this conduct doesn't apply or certain conduct just isn't anti-competitive, full stop. That just makes life so much easier for a judge because you don't have to get into the weeds of the facts and the details to figure out the actual anti-competitive effects and who's harmed. So one of the things is sort of making the complex facts and the harms on the ground accessible, approachable, understandable. And this maybe is the link between Ida Tarbell and Lina Khan. Is one of the things they both did is they both went and researched, the behemoth of their times, and systematically, in accessible language, explained why what they were doing was anti-competitive. And I think that that's what you're going to need to do is to explain why this conduct, how this conduct actually happens, and why it's anti-competitive, and then argue for what role antitrust should have in remedying that.
It's a very interesting comparison because I think, Professor now Chairwoman Khan's article, I think was influential. But it was not a fact article. In a sense, she did dig in on the facts, but a lot of what she talked about was rethinking antitrust doctrine, something that I don't think Ida Tarbell was about. Ida Tarbell was really about getting her hands dirty and digging into the facts. So I think that might be one difference.
You're absolutely right that Ida Tarbell, I was going to say Ida Tarbell was an investigative journalist. That's not fair. Ida Tarbell created investigative journalism as we know it, but she wasn't a lawyer. So she was exposing the facts that then could be used by lawyers. Lina Khan comes to this with the skill set of an investigative journalist and the mind of a lawyer, and therefore can take that next step into what to do. Actually, ironically, Ida Tarbell, after this, wrote a series on tariffs, doing the same thing of explaining why they were bad, how they harmed consumers. And President Wilson offered Ida Tarbell a position on the Tariff Commission, which she turned down because she thought it's not going to be effective because corporate interests are going to dominate. Whereas Lina Khan, of course, did not turn down the call for government service and is leading the FTC now, but she's leading it with an understanding of history and antitrust law and how to connect the two.
So, Professor Leslie, I'm going to tell you something I don't want you to think less of me. There is a drunk history episode on Ida Tarbell, and I commend it. I commend it to all the antitrust nerds like myself who also might like drunk history. But at the end of the drunk history, it was actually it's funny, but it's also pretty well done and thoughtful. At the end of the episode, the narrator says in a sort of joking way, okay, so Ida Tarbell made the world safe for competition among petroleum companies. And now we are in a very competitive environment where we have two of them, Exxon and Chevron. So the joke is that despite all of this, here we are, and our focus on that particular area, there is a high level of concentration. What do you see? Do you see anything happening now that may change the direction that we're going in? That may make that may make Ida Tarbell's ultimate legacy be a little more successful, at least in the eyes of the people who make drunk history.
Well, so the way you positioned that, it was as if we had this great success and now we've reverted back to this concentrated market. In reality, although the Supreme Court broke up Standard Oil into all these different components, Ida Tarbell recognized right away that all these different components that are former Standard Oil still don't compete against each other in a meaningful way. And in fact, they sort of operated at least sort of as a tacit cartel, if not an explicit one. And the profits skyrocketed. Rockefeller made so much more of his money after the dissolution of Standard Oil because, of course, he owned parts of all of the different baby Standard Oils. So the problem is, how do you make firms compete against each other? Standard Oil, in some ways, is sort of a Section 2 story because it was an illegal monopolist and was busted up. I mean, maybe the answer to your question is to sort of recognize it's not enough just to enforce Section 2 of the Sherman Act. We need to have meaningful enforcement of Section 1 of the Sherman Act. I mean, let's also make it harder for firms to collude with each other. My current research is on how courts have made it functionally impossible to prove collusion through circumstantial evidence. And maybe that's one of the things we need to do is to make sure that we have multiple players in the market, but then to also make sure we've got vigorous enforcement of Section 1 so that these firms can't collude with each other.
Professor, thank you. That was a very, very interesting discussion, and I hope we can have you back as things develop. To help us think more about these sorts of contextual issues. But I'd like to shift gears for a second and ask you a couple of unrelated questions. The first of which is, do you have any advice for younger lawyers who want to do what you do?
Study what you're passionate about. That find issues that are interesting to you. And to really research them. That, Lina Khan, as a law student, was very interested in what Amazon was doing and was told by a lot of people there's no there. And much to her credit, she persevered, that she ignored the people saying that there's no there, that Amazon isn't doing anything wrong, or you're not going to be able to hold Amazon accountable, that she knew that they were doing something anti-competitive that wasn't receiving enough attention, and she pursued that. Ida Tarbell's book has been called the most important book about business in American history. Lina Khan's law review note has had such a tremendous influence, and it's because she researched what she was interested in and pursued it. That's the big thing I would say, is find areas of law that you think that there's some there. And the way that we're talking about this, I'm saying find antitrust violations. But if you think that somebody is being falsely accused of an antitrust violation, or if you think that conduct that firms are engaging in that should be legal, but find something that you're passionate about, research it and write about it and get your viewpoint out there. It can really have an effect on how markets work and how the law evolves.
Yeah, and it could even be a theoretical point too. How we should be interpreting a particular statute and not any area of law as well. I think that's great advice.
I would say, well, go ahead and research your theory, but if the facts disprove your theory, abandon your theory, please.
Yeah, yes, I think that is the lesson. Well, and Professor, tell us something interesting about yourself that we wouldn't know if we only knew you professionally.
Well, my husband and I love to travel. We've been to all 7 continents and are looking forward to being able to travel again.
What of the 7 continents? I think I have been to 6. So I'm guessing the one I haven't been to is Antarctica.
You should go.
How do you get there? Like, how do you do that? Are there flights?
Not to Antarctica. I think that the only way that us regular folks can go there is by boat, and the boats leave from Ushuaia, the city at the southernmost tip of South America. And we went on a boat that was the first National Geographic sort of tourist expedition there, and got to spend 10 days hiking around each day on different parts of the continent, seeing the penguins.
And what's it like? Is it just completely empty?
There are thousands of penguins. My first response was to say it's cold, but it really wasn't as cold as Chicago when I lived there. But the other thing is you're much more planned for the weather. We went hiking up a glacier one day, and you start off with like full layers, and the more you hike, the warmer it gets, and you take off a layer of clothing, you just like throw it on the side of the glacier until you like reach the top, and you're just sort of in your t-shirt and regular pants. And then on the hike back down, you slowly pick up an article of clothing that you've left behind until you're fully clothed at the bottom again. The coolest thing, if I can say, about it is there's a place called Deception Island, which is a caldera of a volcano that is a bay, and your boat can like sneak in. It's not obvious how you get in, but your boat can sneak into this caldera. And there's an old abandoned whaling village there. And you can dig a hole in the sand beach. It will fill up with incredibly hot volcanic water. But then you dig a canal to the Antarctic freezing water into that to moderate the temperature. And then you get into your swimsuit and you sit in a hot tub, in a homemade hot tub in a beach in Antarctica, as you regulate the temperature by how much of the Antarctic water you let in to cool down the volcanic water. That was pretty cool.
So let's go to our final segment that we call The Curious Hat.
And now it's time for The Curious Hat!
Okay, Professor, when we are together, I typically have a hat. It can be any kind of different hat, but we have the questions in the hat, and I would hand you the hat. You would select the question out of the hat, and I would ask you that question. Since we're doing this virtually, I'm going to ask you to choose a number between 1 and 20, and I will read the question that corresponds with that number.
18, please.
Okay. Question number 18. What is the accomplishment that you are most proud of?
When I was in college, I was the National College Debate Champion with the UCLA Debate Squad. And that was the accomplishment because it was years of hard work to get there, and I did it with a group of my friends that I now consider my family.
Okay, 2 final questions. 1, is there anything that you would do to try to intimidate your opponents before a debate? Is there something you can do? Can you do that in debate?
I think by just developing a reputation for being skilled.
Do you have like entrance music or anything like that? like the ball players when they come up to bat, do you have a thing like
the eye of the tiger every round? Yes. No,
that's not how that works.
And now I look back on my life with regret and realize that was a huge missed opportunity.
And then, is there anything you can do to kind of heckle your opponent? Is there any trash talking in debate?
No. Not the way that my debate partner and I did it.
Well, that's a shame. Professor, thank you again for being here. This is great fun to talk to you. I hope we'll have you back. And we will see you next time on Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.